So, good morning, everyone, and welcome back to our weekly webinar series. A very important topic. A lot of cases are stuck because of the Enforcement Directorate actions. Over to Anil sir to understand what can be done about them and how can IBC resolve those issues.
Thank you, Ankit. So, welcoming to all the participants in 106th episode of AAA Weekly Webinar Series. As we all know, this is our way of learning, and the attachment of assets by investigating agencies, and most important is the Enforcement Directorate, is a key issue where the cases are not being resolved under insolvency law. So there are so many litigations, contradicting judgments, and we are trying in this episode, we will briefly attend to the provisions of PMLA in a kind of layman's language. Then we will try to understand what kind of provisions are available under IBC where some cases can be resolved. And the most important is that the recent judgment from Bombay High Court in the case of Shiv Charan, that is very important and actually gives us some hope of getting some resolutions. The entire subject is very lengthy, so therefore it will be in two parts, part 1 and part 2. In part 1, we would be deliberating on the key provisions of PMLA, objectives of the PMLA, authorities under PMLA, and also key judgments of Supreme Court under PMLA. Also, we will touch base on that very important judgment released on 1st March 2024 by Bombay High Court. And in part 2, we would be deliberating on various other judgments of NCLAT, High Courts, and NCLT, dealing with the attachment of assets under insolvency law. Primarily, there are three types of cases under litigation. One, where the attachment was done before the commencement of CIRP. Second, where the attachment was done during the CIRP or during liquidation. Then the question of moratorium under Section 14 is discussed. And then is the attachment is done once the resolution plan is approved or the asset is sold under liquidation. That is where Section 32 capital A of the IBC comes in the picture. So these three kinds of litigations that we would be deliberating. So coming to the PMLA part of it, the PMLA part of it is in fact what we are trying to say that, like, in fact, normally we kind of, as a layman's language, it looks like Prevention of Money Laundering Act. As a chartered accountant, as a layman, we in fact were thinking that it is something which is a conversion of black money into white money. That is what is called money laundering. See, however, when we looked into the judgment and the amendments made under this Prevention of Money Laundering Act, PMLA, it is a very larger subject. It is not only conversion of black money or conversion of ill-earned money, ill-taken money into white money. It's nothing about money laundering. It is nothing about converting black into white. Now, basically the preamble of PMLA says that to act to prevent money laundering and to provide for the confiscation of property derived from or involved in money laundering. So this preamble is, in fact, very old, and of late, in case you see, this preamble also should have been changed. Now, but then the preamble remains the same, but the definition of money laundering has been changed. The law, in a very layman's language, says that if there is any proceeds of crime earned out of offenses, earned out of illegal acts, earned out of kind of those various provisions of Indian Penal Code, by cheating someone, by concealing the property. There are various sections of Indian Penal Code where the money is ill earned and the PMLA is applicable. Then the Narcotics, Drugs and Psychotropic Substances Act, then all Unlawful Activities Prevention Act, and several other acts, because there is a schedule 1, and in that schedule 1, there are various acts and various sections. Those are mentioned. So all those sections, in case it is invoked on a particular, if it is alleged against a person, then the PMLA can be initiated, PMLA activities can be initiated. So this is basically, originally it was meant for kind of like it was meant for like kind of limiting the criminal activities, terrorism, drug trafficking, human trafficking, corruption, and that's what was the original offense. When we see the definition of money laundering under PMLA, Section 3 deals with it. It actually is nothing about conversion. No, it says it says proceeds of crime, including its concealment, possession. Basically, the any kind of activity where the proceeds of crime, like we are doing a crime and we are earning something, that is called proceeds of crime. What crime is covered under PMLA is mentioned in Schedule 1. Proceeds of crime, its concealment, its possession, acquisition, use, and even projecting or claiming it is untainted money. So basically, tainted money converting into untainted money is only one part of it. Tainted money converting into untainted money is only one part of it, whereas all other parts are also included in the PMLA activities like concealment, possession, acquisition, or use of ill-earned money, tainted money, proceeds of crime. So this is where I wanted to focus, that the name of Prevention of Money Laundering Act is not really like going clearly with the law. It is even possession. It is not conversion of tainted money to untainted money. The PMLA gives a lot of powers to its authorities. First of all, Enforcement Directorate is the designated authority under PMLA. And the powers of Enforcement Directorate are extensive. It includes like in the investigation, attaching properties, initiating proceedings, confiscating proceeds derived from money laundering. Money laundering means proceeds of crime. Then, like Section 5 also deals with the seizing the properties which is linked to money laundering investigations. Then there is a presumption in Section 24. There is a presumption in Section 24 of PMLA Act. Actually, that presumption says it is presumed that any proceeds, any property found will have some connection to money laundering. Money laundering means like tainted money, ill-earned money, proceeds of crime. It has a presumption. It is on the accused to prove that it is otherwise. It is the other way. The Section 8 even grants power to the Enforcement Directorate to arrest, attach properties, search, seize properties, and so this is even the Supreme Court has also affirmed in this Vijay Madan Lal Chaudhary judgment of Honorable Supreme Court has confirmed that the PMLA provisions are constitutional. There is no issue of constitutional validity. We will discuss that judgment also in length, but the powers are completely now even settled with the Supreme Court judgment in the case of Vijay Madan Lal Chaudhary versus Union of India. Now, the authorities under the PMLA is like once the Enforcement Directorate registers a case, whenever the case is registered, it is actually called slightly different. Normally, we call it case as a FIR. However, in the case of PMLA, we don't call it FIR, we call it ESIR. Now, the ESIR is kind of enforcement. ESIR is something which is related to the enforcement. It is not FIR. So what we are trying to say is that the authority under the PMLA is the, first of all, the provisional attachment order is issued by the Enforcement Directorate. Whenever they come out with ESIR as against FIR, and the beauty of the ESIR is the like kind of it is a private, like in the case of FIR, it has to be on the public domain, whereas in the case of information report of enforcement, information report is the private document. It is not even supposed to be disclosed to anyone. The only thing is that the ESIR is made and the assets are attached by the Enforcement Directorate by way of provisional attachment order. Now that provisional attachment order will actually go to the adjudicating authority. The Enforcement Directorate will go to adjudicating authority under PMLA, and that adjudicating authority will either confirm or will say that no, this is not a right attachment, this is not a right case. But most of the cases, almost 99% cases, the adjudicating authority will confirm the attachment orders. This is the like the adjudicating authority in Delhi is available. It's basically it's in Jeevandeep building. Then there is another authority which is the Appellate Tribunal under PMLA. There is a history for the Appellate Tribunal under the PMLA. In fact, this tribunal was one of the very first tribunals made in India, and originally this was called as Appellate Tribunal for Forfeited Properties, ATFP. Appellate Tribunal for Forfeited Properties was the first tribunal. It was one of the first few tribunals made in India, and that was made under SAFEMA. Under SAFEMA. SAFEMA is a law which is Smugglers and Foreign Exchange Manipulators Forfeiture of Property Act 1976. So the Appellate Tribunal was made under SAFEMA. Even today, it is called Appellate Tribunal SAFEMA. The name has not been changed. This particular SAFEMA Tribunal, Appellate Tribunal SAFEMA, it was actually used to have the appeals out of the Sea Custom Act or out of the Customs Act or Foreign Exchange Regulation Act, and also COFEPOSA, the confiscation of foreign exchange, like that was a COFEPOSA was the law. Then later on, even this NDPS Act came, this Narcotics, Drug and Psychotropic Substances Act came in 1985. Then the Prevention of Money Laundering Act was enacted in 2003. And in Finance Act 2016, all these various acts, the appellate authority, like the Appellate Tribunal SAFEMA, was made the appellate authority under the Prevention of Money Laundering Act, under the NDPS Act, under the Prevention of Corruption Act, and also the Benami Transactions Prohibition Act. And finally, this SAFEMA, finally the Appellate Tribunal SAFEMA, which is also called Appellate Tribunal Forfeited Properties APFP. So this particular Appellate Tribunal is presently attending to the appeals filed under under 5 acts. One is SAFEMA, and there is the NDPS, and then the PMLA, and the Prohibition of Benami Property Transactions Act, and FEMA, and also any kind of penalties imposed by Financial Intelligence Unit. Also, the appellate jurisdiction is with Appellate Tribunal SAFEMA. The office of this tribunal is in Lok Naik Bhavan, and this tribunal has 5 members. So this is where this is, and any kind of order of Appellate Tribunal SAFEMA or Appellate Tribunal PMLA is appealable in High Court, and then of course again Supreme Court. Now the PMLA is invoked when there is a predicate offense, and then there is a property which is proceeds of crime, and the activity of the concealment, possession, use, acquisition of the proceeds of crime. That's where the act is presently being applied. And as I said, various provisions of Indian Penal Code, Prevention of Corruption Act, SEBI, Customs Act, Copyrights Act, Trademark Act, Information Technology Act, Environment Protection Act, Water Act, Air Act, even fraud under the Companies Act, And when we actually talk about the various provisions, like when the bank files a complaint, before CBI regarding the banking fraud, regarding the fraud with the bank, like in the case of Nirav Modi, or in the case of Mehul Choksi, or in the case of other many cases which are where the complaints are filed by the banks to Joint Director CBI, and finally the provisions of PMLA was invoked. That was under the various provisions of Indian Penal Code, which actually can be like concealing the properties or like misrepresentation. All this is the various provisions, and the where the cases can be invoked by under PMLA by Enforcement Directorate. The investigating agency like Enforcement Directorate, which is under the Department of Revenue, Ministry of Finance. That Enforcement Directorate is the investigating agency which has many more powers. It has the powers of search, seizure, statement recording, and then also the Financial Intelligence Unit. Financial Intelligence Unit, FIU in India, it is also under the Department of Revenue, Ministry of Finance. That is also an independent body, like reporting directly to Economic Intelligence Council, again headed by Finance Minister. Then the offenses are investigated by the agencies like Police, Customs Department, SEBI also investigates, like and Narcotics Control Bureau also investigate, and the CBI also investigate. So these are all the investigating authorities. When Police, Customs, SEBI, NDP, or NCB or CBI is doing the investigation, then they can finally refer that case to and notify to ED that they have found some proceeds of crime and which are covered under the scheduled offense. Therefore, they refer the case to ED. So the police can refer the case to ED, Customs Department's investigation can refer the case to ED, SEBI can refer the case to ED, Narcotics Control Bureau can also refer, and also the CBI can also refer the case to ED. And like when there is a finding, whenever there is a finding of proceeds of crime and acquisition, use, and all this of proceeds of crime, then the case can be referred to the Enforcement Directorate. And Enforcement Directorate can freeze the property, seize the property, can seize the records, and also kind of attach the properties, and also like rigorous imprisonment, which is 3 years. And in some of the sections, some of the law, like it is even 7 years. So the imprisonment is 3 years in most of the law, but in some of the heinous crimes where the proceeds of crime is also there, it is for 7 years. Now the procedure, as I said, that when they attach, they issue a provisional attachment order. Then finally the attachment is confirmed, and that attachment is confirmed by the adjudicating authority. Appeal is filed before the appellate authority under PMLA, which is called the Appellate Tribunal SAFEMA. And then the attachment also gets confirmed if after every then the ED has to file a case. There is a special court under PMLA, and that special court is the session court equivalent. And in that session court talks about arrest, bail, and session court also is empowered as per the judgment of the Vijay Madan Lal Chaudhary. The special court is also empowered to release the attachment on any assets in case it is found to be incorrect attachment. And also the appellate tribunal under PMLA, means appellate tribunal SAFEMA, is also has the power of detaching the assets in case it is incorrectly attached. So when we talk about these all these provisions, the I think what we are trying to say now, it's like appeal of these goes to High Court, and now Ankit, we actually would like to say uh, when the attachment of the properties are done, and suppose the attachment is done for any private limited company or a limited company and or LLP, assets are owned by these three entities, and the company goes into insolvency. In fact, then there is a clash of provisions, the clash of provisions of IBC and PMLA. This is the beginning. PMLA we have seen, and then we saw that the uh, PMLA also was an act in 2002 which came with the non-obstante clause, that all the various provisions of PMLA is like kind of over and above any other thing mentioned in any other law. Similarly, in IBC also, it is mentioned that the provisions of IBC, various provisions of IBC are having non-obstante clause in section 238, also have a non-obstante clause, and also section 32A starts with the non-obstante clause. So the key objectives of the IBC, which has been actually used when the courts are passing order in favor of RERA, the key objectives of the uh, IBC is the ensuring availability of credit, balancing the interest of stakeholders, providing a structured frameworks for recovery and addressing the insolvency. So that is something which is considered to be the key objectives of the insolvency. And when we see the clash between clash between PMLA and IBC, the clash between the PMLA and IBC, the first clash is there are contrasting claims. One, that under IBC, the secured creditor says that the property is mortgaged to us and we have the superior charge on these properties, and the PMLA attachment has actually been done after our charge was created on the property. So therefore, we have the first right under section 53 in case the company goes into insolvency or liquidation. That is the first clash, the kind of clash arises between PMLA and IBC. And the PMLA says that it has a right to attach, it has a right to ultimately sell, and whatever the proceeds will come, it will go to central government. The ultimate of PMLA is that all the properties are attached, all the proceeds of crime, which whatever it was invested, wherever it was invested, in case finally it is held that these are the properties acquired out of tainted money, then that properties would be finally sold, that bank accounts finally, the money lying in the bank accounts will be transferred to central government exchequer. So that provision and the provision of section 53, that is a direct clash of PMLA and IBC. Then the clash is that in the IBC, it is considered as the objective is the maximization of the value, continuation of the business, continuation of the employment, continuation and survival of the business, while the PMLA objective is to confiscate and attach any property which is involved in money laundering, ill-gotten money, tainted money. That is these are two objectives. So that objective and this objective doesn't match, absolutely no matching. Then section 71 of the PMLA Act also says that the provisions of a PMLA shall apply regardless of any contradictory or overlapping provisions in any other legislation for the time being in existence. Similarly, section 238 of the IBC also says the same thing, exactly same thing. However, both these PMLA and IBC has non-obstante clause, and that is also clashing to each other. Now, the secured creditors who are actually having the first charge, they have given loan against those properties, they have given loan against those assets, and the promoters have just invested their margin money, and most of the money is invested by the secured financial creditors, which are the public sector banks or financial institutions, and they are actually also having the public money with them. So that is also is a conflict and clash of provisions. The assets are attached, whereas the charge is with somebody else. That is something which is again. Then when the insolvency starts, the resolution professional has a right under the IBC to take control, to take possession and custody of the assets. And irrespective of anything attached by any other person, like whatever it is, if the asset is owned by the corporate debtor, it should be taken and in control by the RP. That's what is the provision, and the liquidator with whatever is applicable. Now, in this case, when the RP approaches the PMLA or RD approaches the ED, the possessions are not given to the RP. There are many such judgments which says that the IBC is not overlapping the PMLA. Therefore, the RP cannot invoke Section 14, and therefore it is not possible for the courts to pass an order directing the Enforcement Directorate to hand over the possession, control, and custody of the assets and properties which are already seized under PMLA. So these are the many judgments that we have seen. Then we also talk about Section 14. There are many judgments on Section 14 where the assets are attached, seized, bank accounts are seized during CIRP or during liquidation. So during CIRP, Section 14 is invoked, and the RP normally says that it is Section 14 and you can't do, there no legal proceedings can be initiated. However, even I have gone in 2 cases up to Supreme Court. One has already decided in my case, and the other is still pending before the Supreme Court. The Supreme Court summarily, in the very first hearing, dismissed the appeal, while the NCLAT has said that the RP cannot invoke Section 14 to get detachment from PMLA. RP should go to various other remedies available under PMLA. So that is what NCLAT said. And when I filed the appeal, it was dismissed in the very first hearing by Honorable Supreme Court. Then came Section 32A in IBC. When this Section 32A came, it was, I think, considered as a hope that anyone who actually takes over a company under the insolvency law as a successful resolution applicant, or anyone who buys any asset under liquidation under IBC, they would be protected from the provisions of PMLA, and those properties would be free and those properties would be detached. So therefore, like there was a general opinion amongst the professionals that this Section 32 capital A that will actually protect the interest of secured financial creditors. However, so far it is too late. It is like it's about 3 years that this section has been inserted in IBC, but not much has so far been achieved. So Ankit, is there any questions so far here? We can think about any question.
No questions so far.
So anything that you would like to add before I go to, before I discuss this judgment of Vijay Madan Lal Chaudhary versus Union of India, because that's an important judgment under PMLA?
I think we should talk about this judgment and kind of try to conclude on what is the present status of all the ED cases, and in various scenarios, what should the RP or what should the stakeholders do.
So fair enough. So I would just see that this is this Vijay Madan Lal Chaudhary versus Union of India. This is a judgment which has come from Honorable Supreme Court of India, and on 27th of July 2022. And this judgment is a landmark judgment. And in the case of another review, there was some review also, and in the review also, this judgment is finally, it has been upheld. And in this particular judgment, the most important part of this judgment was that the Honorable Supreme Court upheld the constitutional validity of PMLA as a law. And it also held the various provisions of PMLA, like the absolute powers granted to Enforcement Directorate, and which is a supervising agency for PMLA. And the judgment, this judgment also kind of restricts the rights of the accused, emphasizing that the authority of the Enforcement Directorate is actually much larger, and they can attach properties, they can search, they can seize, and various actions of the Enforcement Directorates as provided in the PMLA law was in fact upheld by Honorable Supreme Court. So in this judgment, it was also discussed that bail is a rule and jail is an exception. However, in this case, under PMLA, there are two conditions which is required before a person is given bail. One, that the public prosecutor has been given an opportunity to oppose the application for a release and bail, and also there should be a reasonable ground for believing that the accused is not guilty of any such offense, and that the accused is not likely to commit any such offense while on bail. So these two conditions have to be fulfilled before a bail is granted. So therefore, it is clearly held in the Supreme Court that the PMLA, or the wide power of the Enforcement Directorate, arrest powers of the Enforcement Directorate, and there is a presumption that any proceeds, any asset, any proceeds of crime, any tainted money, any kind of properties found, whether it is the proceeds of crime directly or even connected with the proceeds of crime, there will be an assumption that this is a tainted money, this is an ill-gotten money, and the responsibility shifts to accused immediately that the properties are not tainted. So that assumption is also held as valid, and it is not considered to be violative of Article 14 and Article 21 of the Constitution. Now, like again in Section 3, it was argued that when this law came, it was only kind of an effort of converting the tainted money to untainted money. It was focused on conversion of black money to white money, but the Honorable Supreme Court said, but that's not the requirement. It was argued that everything is okay, but there is no effort seen that the tainted money is being converted into or being projected as untainted money, or the black money is being converted into ill-gotten money is converted into kind of clean money. So that also the Supreme Court said that that's not the requirement. So the Supreme Court, in fact, it also upheld that the mere possession of the proceeds of crime also constitute the money laundering. Mere possession or mere possession of the properties purchased out of the ill-gotten money, purchased out of the proceeds of crime, is also considered as money laundering. Attachment is the power that was also upheld, that the attachment can be done, and also seizure and search and seizure was also upheld, that powers of search and seizure. Arrest was also upheld, and the recording statements was also upheld. It was also kind of discussed that the secured creditor, they have a right to present before the authorities that they have a first charge. So what is open so far is that all these authorities, like special courts under PMLA, appellate tribunal under PMLA, which is the appellate tribunal SAFEMA, they all have power to release an asset if it is not owned, if it belongs to somebody else, or if it is not purchased out of the proceeds of crime. So therefore, most of these assets which are mortgaged to banks, which is acquired out of the loan taken from the banks, those actually should be released. However, the judgments are pending and the decisions are not coming. But other than this, in the case of Nirav Modi, which is being handled by us, we are the liquidators for, as a AAA insolvency, is the liquidators for the Nirav Modi companies, for Mehul Choksi companies, all companies, and for the Vikram Kothari companies, for the REI Group, Junjunwala companies. So all these cases, the assets are attached by Enforcement Directorate, and we are actually fighting many cases here and there and at various locations, at various kind of litigations. So the enforcement case information report, which is ECIR, it is even the Supreme Court also have held that this is not something which is FIR. the first information report and enforcement case information report, these are two different things. And the FIR, like something, FIR must be forwarded to the jurisdictional magistrate, and this is not even required for an ECIR. The ECIR is not even supposed to be given to the jurisdictional magistrate. The ED can arrest a person based on enforcement case information report without even disclosing its contents and without even disclosing its contents to the court. That also was held as not arbitrary by Honorable Supreme Court. Unlike FIR, because first information report, the providing a copy of the ECIR to the accused is also not important. In the case of FIR, the accused must get a copy of the FIR. However, in the case of ECIR, it is not even important that the copy should be given to the accused. Copy is not required to be given to the jurisdictional magistrate. What is required that there is a ECIR, and that's an internal document of Enforcement Directorate. The ED need not disclose the grounds of arrest. ED need not disclose the grounds of arrest. It is on the other party. It is on the accused to prove that there is no charge against me. It is like, that's a very, very kind of difficult, but yes, this is what is ECIR. Then in this judgment itself, like Vijay Madan Lal Chaudhary versus Union of India, it is also mentioned that the authority to release or detach the properties that have been attached as part of the enforcement actions lies primarily with the adjudicating authority. And then it is also said that in case the adjudicating authority is not convinced about the claim on the assets of the accused by any third party, then the appellate authority, like the appellate tribunal under the PMLA, which is appellate tribunal SAFEMA, that tribunal has the power to release. And of course, when any appeal is filed, because the appellate tribunal SAFEMA, the appeal lies before High Court within 60 days. So that appeal also, the High Court also has a power to release or detach the assets attached under PMLA. So various judgments that we can see. Ankit, now the PMLA judgments or PMLA provisions are over. So should we go for the IBC judgments now, or
We can take
there are
some.
some
We can take
questions?
some questions. So we have a question from. We have a question which is how the third party secured property release when the company loan is settled with bank lenders. So I think third
So
party.
if the loan is settled with the bank, then the bank doesn't have any charge on those properties. Now, what this PMLA is talking, that yes, in case you have a charge, like see, the High Court has also said, Supreme Court has also said, attachment doesn't mean that your charge is disturbed. They have said very clearly that if you have a charge on the property, that actually will be dealt with by Section 53. Now, the Section 53 is not changed. Confiscation, attachment is separate thing. But in case finally it will be held that the properties are supposed to be taken out of the proceeds of crime, then again your charge would be valid. Your priority charge on that asset would be valid. But in case the bank account is already settled, bank loan is already settled, then there is no charge on the properties by the secured financial creditors. Then actually it will go to exchequer, central government.
All right. Then we have Sanjeet Das ji asking, in case PMLA applicability is prior to IBC invocation, then PMLA appellate authority is the deciding authority. That's his question.
Yes, PMLA appellate authority. See, there are three kinds of litigation that we are going through. One, when the provisional attachment order is passed by the Enforcement Directorate, then Enforcement Directorate files that provisional attachment order before adjudicating authority under PMLA. At that time, the RP or the liquidator or even the banks can approach adjudicating authority under PMLA, saying that the assets are mortgaged to us, and the assets were in fact, because see, what is happening is at the time of provisional attachment order, even the FIR, final FIR is not released. Charge sheet, which is called charge sheet. The charge sheet is also not released. So in the charge sheet, we will come to know what is the period of crime and what is the kind of proceeds of crime according to the charge sheet. Then the secured financial creditors can say that the asset which is mortgaged to me was acquired much before the crime period. Asset was acquired and mortgaged to bank much before the crime period, as mentioned in the charge sheet. So therefore, this asset is not covered under the proceeds of crime. So the attachment is incorrect. That is the first thing that the enforced RP can do, liquidator can do, or even the secured financials can do. That they can do. They can do this before the adjudicating authority under PMLA. Historically, that adjudicating authority under PMLA is not doing any detachment, because by that time, the facts are not completely available. ECIR is not available. Charge sheet is not available. So in most of the cases, the provisional attachment will get confirmed by the adjudicating authority under PMLA. Then the rights are available with the liquidator, with the RP, and with the secured financial creditors to file an appeal before the appellate tribunal SAFEMA or appellate tribunal under PMLA, whatever name you call it. In that appeal, you can always say the same thing, that the proceeds of crime, the time of the crime, the time when the assets were acquired, and the amount of loan which was given, and therefore all these merits can work there before the appellate authority under PMLA, and that is the first authority where some success can be received. And then in case it is not possible, then High Court and then Supreme Court. So this is the first line of litigation. The second line of litigation is the special court under PMLA, which is equivalent to session. In that court also, the any kind of owner, any person who has a claim on the asset can also claim. This is called filing of the claim before the special court. So the claim can be filed by any interested party, maybe RP or maybe secured financial creditors, before the special court, which in fact Punjab National Bank has done in the case of Nirav Modi, and special court released the assets of Nirav Modi in favor of the liquidator, because the Punjab National Bank has actually gone to the special courts under PMLA, and that special court considered that application and released the assets to Punjab National Bank, and those assets are presently being sold and the proceeds are being distributed to banks. And from the special court under PMLA, again, the appeal goes to High Court and again goes to the Supreme Court. This is a second line of litigation. The third line of litigation is that we actually, in case of RP or in case of liquidator, the first application can go to NCLT, adjudicating authority under IBC, and then an appeal before NCLAT, and then to Supreme Court. So these are the three line of litigation, which is in all cases of enforcement directorate attachment, all the three kind of litigations are going on.
Then, of course, we have a question that Ravi ji is saying that I appeared before the SFIO. The promoter excused himself that he does not have access to books, and SFIO was asking for old records. Similarly, they also called the CS and CFO for investigation, who resigned long ago. So, how to deal with such queries? So, SFIO is seeking details, and the RP is being asked for giving old records, and the promoter simply excuses himself that does not have access to books. I think the answer lies in the whole idea that, especially the revised regulations that have been in place for over a year now clearly say that the RP is supposed to prepare a detailed notice writing to the promoter that what has been received and what is pending. So in case the RP has done his duty, where he has written that kind of notice to the promoters, listing out that this is not received, this is not received, this is not received, then that document in itself will be, of course, something that SFIO can be, attention of SFIO can be brought to. Because this confusion, then that document can be, of course, put before the promoter, and the promoter can then kind of answer that question, that why did he not provide those details. So this is a common practice not to provide these details.
I can add, Ankit, what you are saying is absolutely right. But then I think the most of the queries, the queries are talking about something which is before this regulation came. Now, there is hardly any evidence that what has been handed over by the promoters to RP, and the RPs in any case also didn't have much of the evidence that what has not been handed over to RP. So therefore, whenever SFIO or CBI or ED seek information from the RP or the liquidator, it is the duty that we have to give that information to the extent available. In such scenario, any application under section 19 subsection 2 actually will come to the rescue of the RP. So therefore, now even section 19 subsection 2 has to mention very crystal clear manner that what is received and what is not received. So therefore, because earlier this 19 subsection 2 application was considered to be a kind of like saving kind of the skin of the RP, and therefore now this is again section 19 subsection 2 application has to be very, very clear, along with the Panchanama issued and made at the time of receiving information, assets, and records. So that has to be part of the applications under section 19 subsection 2. So there will be complete records. In fact, in many of our cases, the CBI came to our office for many days, and they in fact took all the custody control on the various records of the corporate debtors. We have been summoned to various offices of Enforcement Directorate. We have been summoned in various offices of SFIO, and we also have been summoned by various investigating agencies appointed under the Companies Act and working out of the Office of Registrar of Companies. So therefore, we are actually going, and it is very important for all the RPs to be ready, have information, and the committee of creditors should be prevailed upon that they should give you proper amount so that you can shift all those records and from the premises of the corporate debtor to another premises in case the resolution plan is, in case the company goes into liquidation. However, in case the resolution plan is approved, then such kind of a record handing over process to the successful resolution applicant should also be conducted, so that in future the duty gets shifted to the successful resolution applicant for providing information to investigating agencies. So simply handing over a company to successful resolution applicant without creating records, that also can be harmful to RP.
Then basically, question seems to be a specific question. 4 years ago, bank account was attached by the ED. Post that, DD of 13 lakhs lying with the CD was refused to be paid by the bank. Now the company is under CRP. Please guide with the process to be followed to encash the DD. I think
No, I
it's
think it is again the attachment of an
yeah,
asset. As I have said, there are three lines of litigation. One is through the NCLT route, the other is through the route of special courts under PMLA, and the third is the adjudicating authority under PMLA and the appellate authority under PMLA. So these are the
so
three.
DD amount is debited from the account when the DD is prepared. It is not that the DD is not debited. So if there is a DD which is not been encashed, and that DD is an asset of the company. Now, the bank can say that, okay, this 13 lakhs of DD was prepared from this money, and because we have attached the account, the DD is also, attached. So they may not pay this 13 lakh rupees back to the promoter, but this 13 lakh can always join in into that account balance which has been attached by ED. That's, I think,
You
the
are absolutely
course.
right, Ankit. In case there is any account, out of that account, some DD has been made, and that DD is not been encashed, and the bank has all the powers to cancel that DD and bring that proceeds back to the same account.
I think the question here is that the intention or the requirement was that the 13 lakhs can be freed, or rather that can be unattached in some manner. I don't think that can happen here.
It is not unattached because the bank has no power to encash that DD separately. It has to come to that account. And once that amount comes to that account, which is already attached, that amount also gets attached.
Attachment, yeah. So any new credits which come into those accounts which are attached are also forming part of the attachment. That's very, very true.
Yes.
So if some assets of CD have been attached by ED prior to ICD and resolution plan is now approved by AA, what steps to be taken by RPSRA?
No, you see, in case the assets were attached by the ED prior to commencement of insolvency and the resolution plan is now approved and the resolution plan is the successful resolution applicant is complying with all the conditions of section 32 capital A of the IBC, then I believe the very, very latest judgment of Shiv Charan versus the adjudicating authority under PMLA. That judgment is from Bombay High Court. It is dated 1st of March 2024. That would be used. Although I have understood from someone, although I couldn't find it anywhere on the public domain, that yes, the ED has filed an appeal against this judgment of Bombay High Court, which is in the name of Shiv Charan and dated 1st March 2024. That judgment is a judgment which has actually held very clearly, one, that the adjudicating authority has the power to ask the ED, direct the ED to detach the assets. Secondly, the section 32A would be invoked once the resolution plan is approved and the successful resolution applicant will be having assets which is free from all attachments from the enforcement directorate under PMLA. So this judgment will actually be used and you can again file similar applications to the resolution to the adjudicating authority so that your resolution plan is approved by adjudicating authority.
Then we have a question that if the property is under possession of receiver of High Court and economic offence wing, how to release the same under CARP? I believe here there is no gap. The property can come to the control of the RP after NCLT proceedings and so on. What is your opinion?
No, I couldn't understand which attachment by
Receiver of the High Court and economic offence wing, EOW.
No, in many cases, the economic offence wing and the receiver of the High Court, they are having some attachment on the assets of the companies or individuals because of a dispute, because of a complaint. And we have recently handled a case where the assets of a particular company was attached by economic offence wing and the complaint was filed by the home buyers. And NCLT, first of all, said that even before the NCLT, it was in fact this statement was given by the enforcement like economic offence wing that the amount which is lying in this bank account is not something which is proceeds of crime. And then NCLT said that this amount liable to be detached, but NCLT doesn't have the power to detach, so it should go to the relevant court. Then we went to that relevant court, that court which attached the particular account, and that court has also detached that particular account where the amount of rupees 3.5 crore was lying. However, this court has asked for an indemnity bond of 4 crores. Now we are discussing with the COC how to provide this indemnity bond of 4 crores, whether how the RP can sign the indemnity bond of 4 crores, how the responsibility finally can shift to the corporate debtor, even if the COC approves that indemnity bond. So that is what is presently going on, and we will definitely resolve this.
All right, then we have can removal of ED attachment be part of the prayer in the resolution plan, or it makes plan conditional?
No, I see the plan, making a plan subject to a removal of the attachment by the ED, definitely it becomes a conditional. So we actually have dealt with this kind of subject. What is a conditional plan? The conditional plan is that on a particular event, like in the case of Jet Airways, first time the conditional plan was accepted because in that plan it was said that in case the license of airline is not renewed, a license of airline is not renewed, then in that case, the resolution plan would not be implemented and it will not be binding on the resolution applicant. So that was the first resolution plan which was approved subject to this condition. Similarly, if a particular asset is the key asset of a resolution and that asset is attached, and that can also be a condition that in case the asset is not attached, asset is not detached or released by the ED, then this resolution plan would not be binding on me. I think this is a case where it can be argued based on the judgment of Jet Airways.
Yeah, so one can kind of also, plan it around and say that, okay, this payment or this amount that is payable as per the resolution plan will be paid after getting possession of the asset. So
Yeah.
that can be, like that is not condition. That is like simply, talking about what are the duties of the RP or the creditors and what are the duties of the resolution applicant. So
Yeah.
this way it can be handled as well.
Yeah.
Then, whether there's a question whether all loan defaults NPAs will be covered under PMLA ED proceedings. No, we are not saying
No.
that all loan defaults or NPAs get covered in PMLA ED proceedings. PMLA ED only come into being where there is a crime. So what happens is that in case the promoters are behind a crime, only then the ED PMLA proceedings can start, where they have ED has the information that this property has come from some crimes of money, as we said. So that has to
See,
be in the essential agreement.
there is a slight a different scenario which is possible because in the PMLA, I have also seen that there is a clause which actually says that if the I let me see in case I can get the PMLA, and it is a section 422. Give me a minute. Section 422 and 424 of the uh, Indian Penal Code, that actually is also a scheduled crime. Section 422 talks about the so 422 of Indian Penal Code talks about dishonesty or fraudulently preventing debt being available for creditors, and section 424 of the Indian Penal Code, it talks about dishonest or fraudulent removal or concealment of property. So these two sections are covered under the scheduled offense under PMLA. So when this complaint is filed by the banks to CBI, and CBI investigates the manner, because see, there is an RBI circular that in case the in case it is a kind of alleged fraud by the promoters, which is more than 50 crore, then the immediately the complaint may be filed to Joint Director CBI. Now, in the CBI investigation, in case they invoke section 422 and 424, then it becomes a offense which is a scheduled offense, and then the case actually can be referred to ED. Then ED comes into action.
Right. So, plenty of questions. Don't think you'll be able to take up all of them. So,
So I believe, Ankit, what we should do is that the next part two of this, we actually will come out with a lot of judgments of under the ED, like where are NCLAT judgments, High Court judgments, and we will also come out like under what kind of IA all these judgments are presently tagged together, and we all are waiting for the Honorable Supreme Court decision on all these subjects. So we will discuss in case the questions can be taken recorded now, and we will attend to these questions also in the next webinar, that will be 107th webinar of AAA Weekly Webinar Series on the coming Saturday at 11 a.m. So we would be discussing these questions and also various judgments on IBC and PMLA. So that's what I think, Ankit. What do you say?
also in case some of the participants who have these questions which we were not able to take up can also, ask these questions offline. Even that is a good idea. So we can
Yes, yes,
always take them up separately. About
absolutely.
21 questions that I was,
We
yeah,
have
about
Mr. Ritesh
21.
Shah,
Yeah.
in case he can speak out for a minute.
You'll have to ask him to unmute, and I'm not co-host right now, so
So Ritesh, in case you can speak and say your question.
So, I'm audible now?
Yes, yes, you
yes,
are.
you are.
Yeah, very good session, Anilji
Thank you.
and
Thank you
Ankit.
very much, Mangesh.
Just one, yeah, very informative means. One query means uh, one of the company has funded under CSR to one trust. Okay,
Okay.
there is a legitimate money that they have paid to trust as a donation under CSR and
Mhm.
under donation also.
Right.
There are both the things are separately thing. Now that trust got some in ED trouble, and the money which they have received from that company, which is a Fortune 500 within a 500 Fortune company of India.
Mhm.
Okay, now they are saying, okay, whatever fund they are you have received from this company, and you have parked the fixed deposit that we have attached.
Okay.
There is a complete clear money trail. This FD is created from the donation of this company. So
Mhm.
they are not inquiring at the level who has funded, and they are not getting into why they have funded under donation and under CSR.
Mhm.
So they have then given clean check. But on the NGO side, where they have created a fixed deposit, they have attached the FD.
Mhm.
Now, what remedy available with the NGO to get this ED attachment removed? How they can remove?
No,
Proceedings are already going on.
I believe the action is against that NGO, not against the donor.
NGO,
If the
no,
action
not
is
against
against
donor.
the action is against the NGO, so that means all the assets of the NGO are basically presently attached or seized. Now, if
Yeah, partly asset, partly seized asset.
you see, if there is any asset which any other person feels that this is my asset and it was given to the particular trust for a particular purpose, and that purpose has not been fulfilled as of now, so this asset may be given back to me. I think that is the only issue as of now. So an application can be filed before the special court under PMLA, which is equivalent to session court, or the application can be filed before the adjudicating authority, and finally the second step would be to the appellate authority under PMLA, claiming that this
Yeah,
asset.
but how if NGO want to claim this? Okay, this is not the POC. Means this is not this money is not the proceed of crime because they have clear money trail. So how they can establish? Is there any supporting judgment
The,
in
no,
this
see, the
line?
NGO definitely can say, because the NGO has a very larger work to do. NGO
Hmm.
definitely can say that this asset, because the NGO can show the trail, and that's a time-consuming process. Because see, the first of all, the ED investigation, then the like enforcement case information report, which is the ECIR, then the charge sheet, and then all this will finally be like kind of available to NGO for saying that these assets are not owned by me, or these assets belong to somebody else, or these assets are not the proceeds of crime. So they are trying to they see, they will have to say that these assets are proceeds of crime and these assets are not proceeds of crime. But in most of the cases, the enforcement directorate is not presently able to kind of differentiate between the direct relationship to the proceeds of crime and the trail of money. They are not able to. They are saying even in connection with, even in
Hmm.
connection with. So it feels like it is a difficult case, because see, the ED is not presently very actively differentiating the kind of trail of money between the tainted money and untainted money. They are not
Hmm.
trying to see which asset of the accused has actually come from the proceeds of crime and which asset has not come from the proceeds of crime. And they are
Hmm.
saying that for the time being, we are attaching all the assets. And in future, in case any court like High Court may say that the total proceeds of crime in this case is 100 crore, so they will attach assets worth 100 crore and they will reattach all other assets. So that is the ultimate result of the various litigations, maybe finally at High Court or at Supreme Court. But it is a time-consuming process of 8, 9 years. So for the time being, for a quick remedy, I think the special session court or the appellate authority, appellate tribunal under PMLA. These are the maybe something which is less than that ultimate result. This may take about 2 years' time to get a
Yeah.
release from session court or from appellate tribunal. That's what it is.
Okay, got it. Thank you.
So thank you very much. And we are really very happy to see such large audience today. And at the end, we will always say that it is our way of learning. And we will again connect back next Saturday at 11 a.m. Thank you. Thank you.
Thank you. Thank you.